Hi, welcome to Better Informed Housing. My name is Margot Rourke, and today we're speaking with Faisal Elkhatib from Better Informed Housing, an Illinois nonprofit. Tell us a little bit about Better Informed Housing. What do you all do over there?
Well, good afternoon, Margot.
Yeah.
Thank you for introducing me. Better Informed Housing Corporation is a nonprofit organization that's set up to provide education and information to local community on all things related to housing and real estate. So landlord-tenant issues, building violations cases, owning houses, mortgage and finance. So it's a variety of different programs, and it's mostly just educational information. And we do have some partnerships with development and groups that help revitalize neighborhoods as well.
Well, that's very good that you offer information and education, because real estate can be a very confusing area for the average person.
Absolutely. It's a very broad area that involves so many different avenues and types of real estate. In law school, they teach you about the bundle of sticks, which essentially you have take a bundle of sticks, and every stick is a different type of property right, and we cover all of those in our educational programs.
Okay. We had an interesting question come in through the email,
Okay.
and I'd like to talk to you today about receivership.
Okay.
Now, I don't know a whole lot about receivership, but perhaps you can begin by talking a little. What is receivership?
So receivership takes place at very different forms and areas of the law, and it's mostly in this particular case, when it comes to housing or real estate, a receivership is where the court appoints a receiver, which is a person who receives the property and protects the property on behalf of the owners or the bank or the city or the court system. But it's an independent third party that is given the power to oversee the property. Receivership, specifically when it comes to housing, takes place when you have for example, with the city of Chicago, when there's demo properties, and I'm sure we've seen them. There's the boarded up properties they look like they're vacant and abandoned. They're boarded up and they have big red X's on them. So in housing cases, what the city does is, if a property is not being attended to, the weeds are high, or the porch is going to fall down, or there's a heat issue, for example, the heat isn't working in your building and you're renting, you can actually call 311, or a city inspector will be notified to come out and look at the property, and they'll file a lawsuit against the house and against the owners, letting them know that you need to actually rectify these issues with the city because you have dangerous and hazardous conditions. In the event that the owner does not do what they're supposed to do, or the bank doesn't do what they're supposed to do, the city will appoint the receiver, and that receiver will then have the power to step in and rectify whatever dangerous and hazardous conditions that exist at the time.
So who are these receivers? I mean, like, could I sign up and be a receiver, or do you have to go through special training for that, or how does that work?
Well, receivers are usually people who are very familiar with real estate, and they have the ability they usually have construction backgrounds, or they have construction teams that they work with. They are usually go through an approval process with the city of Chicago, where the city will review their credentials, review their financial wherewithal, in order to be appointed as a receiver for the city of Chicago.
Okay. Now, there is a receivership program with the city of Chicago. And so why has this receivership program, why was it started in the city of Chicago?
So, really the receivership program was set up because the city didn't have the funds necessary to do all the work themselves. They do have some money to do some of the work, but there's also instances where they don't have the issues that they can address. So they brought in receivers, or independent private parties, to step in where the government wasn't going to or couldn't come because of budgetary concerns or issues. I think the question that I would always ask is, why is a receiver, or what's the underlying issue? And a lot of that is building violations. So building violations that come up could be anything from, let's say you hired a contractor and the contractor didn't get a permit for masonry, or get the plans necessary to repair a wall. So if the city finds out that you did work without a permit, they'll issue a violation against you. And that violation is that you didn't get the proper permits. So there's usually two areas. You're probably wondering, where do these violations take place? So you have two major areas of the court where they take place. One is at the administrative level, and I believe there's one, maybe two locations, but the primary one is at 400 West Superior. So let's say, Margot, you don't cut the grass in your lawn, and the city will issue a ticket, and you'll have to you'll get a ticket, and then you have to show up to court and say why didn't you cut your grass, or that you cut your grass, you got it taken care of, or that you should have never gotten the ticket to begin with. So the more dangerous issues, and when there's dangerous and hazardous conditions, for example, there's the porch is going to fall over, or the roof is caving in, or the property is abandoned. Those are dangerous conditions where the concern is where someone could fall and hurt themselves, or get injured, or could die. Or if there was a fire, first responders such as the police or the fire department could injure themselves severely if the property isn't taken care of. Holes in floors or holes in ceilings. Those are all dangerous and hazardous that require an escalated attention, and that's what usually get filed at the Daly Center and Housing Court. And those are usually broken up either by type of case, or they're set up across geographical location.
Okay, I'd like to put the information here on the screen so that folks who are watching can get in touch with you if they recognize any of the scenarios that you've been talking about. It's Better Informed Housing. You are an Illinois not-for-profit association, and the primary mission is education and information. So, now, is going into receivership, it sounds like it can be a double-edged sword. It sounds like it can be a really bad thing, or it can be a really good thing. And I'd like you to talk about, what are the downsides of having a property fall into receivership, and really what are the good sides of having a property come into receivership.
So
I see that we have a caller.
We do.
Yes, and I'm not.
Hi, thank you for taking my call.
Thank you for, yes, I don't think you're patched in. Are you patched in?
Yes, I am patched in.
Okay.
At least I think I am.
Yes, well, we
Okay.
can hear you.
Can you hear me?
Yes.
Yes, we can hear you.
Yeah. Okay.
Actually, this happened to my building. I'm in a condo, and last year we had violations in the building, and we were in jeopardy of being put in receivership. And it was actually a very stressful ordeal. And the way it happened to us is, we had gotten violations, but we didn't know until the very last minute. So we didn't have enough time to basically get a architect to drop the plans. But luckily, when we went to the city, it gave us more time. Now, I'm just wondering, as far as a receivership, can it ever be a good thing?
So it can be a good thing, depending on first of all, thank you for your question, and that sounds very stressful, but it can be a good thing. For some of the programs the city has, for example, they get through Neighborhood Housing Services, NHS, and they have a couple other nonprofits, where they'll be appointed as receivers, and let's say you can't afford to do the repairs in your house, they'll do the repairs, the property's owner occupied, then they'll put a lien, the receiver will put a lien on the property, but they won't foreclose and take the house if you're living in the house. And that's specifically designed to give financing and assistance to senior citizens or homeowners who can't afford to do the repairs, but they have to do the repairs. So what happens is when you sell the house, or if your heirs, your children, want to take over the house and want to sell the house, at that point that lien gets paid off. So in those cases, receivership provides money and funds to the homeowner in order to keep their house and maintain their house. Otherwise, the city would be forced to come and either demo or vacate the property if it doesn't get repaired. The other areas, so receivership also helps, for example, I've seen it in condo buildings, where they'll appoint a receiver to step in where the condo association may not have the money to do all the work necessary to fix the building or bring it into code. So in that case, the receiver comes in and can fix all the property, front all the cash, and do all the work necessary to bring the property into code, and then end up getting payments over time, almost like a financing. However, I would say that receivership can be very expensive, and the interest rate is usually between 12 to 15%, and it's a very powerful lien that can actually step in front of the bank's lien. So receivership can be a good thing in some cases, but it usually is a case of last resort as opposed to a first option. The other cases where receivership is very powerful and can be helpful is to kind of bring back, to unblight our blighted neighborhoods. So I'm sure we've all seen them, neighborhoods that have block after block of boarded up houses or vacant lots. So what the receivership can do is it can give an opportunity to private developers to step in and address what we call the zombie titles. So there are times and instances where the owner can't fix the property because they don't have enough money, or the property doesn't have the value to be fixed, and the bank is not going to spend any more money on the property to fix it, and they won't foreclose because it's an area that they don't like or is not favorable to them, or they don't see any value there. So you might have a $300,000 mortgage on a property that's worth $100,000 or maybe even $20,000. So in that case, the receivership can be a good thing, where a receiver is appointed, can do all the work necessary for the property, rehab it, and then use the receiver's lien to foreclose and wipe out the bank's lien. And you wonder, well, why is that so good to wipe out the bank's lien? Well, the bank won't do anything. The owner can't fix it. And so the only option the city has at that point is to demolish the property. And the sad thing is, I know if they don't demo the property, then it's boarded up, it's vacant. It can result to drug activity or criminal activity, or you can have squatters living in the house. And if they're living in the house, then they could be subject to dangerous conditions because the property is not being maintained. So the only other resort the city would have is to demolish the property. And there's some beautiful gray stones and brick buildings that have been around since the late 1800s that the city is demolishing because there's nobody there to fix them. So the zombie title is that nobody wants it, nobody's taking ownership of it, nobody's addressing it, and the receivership, as the caller had, the receivership a receiver could step in, provide their private funds to finance the rehab of the property, and then take the ownership and wipe out the bank's lien. In some cases, there are agreements with the receiver where they'll make agreements with the owners. So it varies. But overall, the receivership is a path of last resort, I guess.
Okay.
So.
Yeah, let's review the way that folks can get a hold of you, Faisal, and
It's at the Better Informed Housing Corporation. We're an Illinois nonprofit. We provide education and information to communities about real estate. For more information, feel free to call us at 312-775-0980, or you can email me at my email at mfaisal, F-A-I-S-A-L, at evlawgroup.com.
Okay. So one last question. I know we're kind of tight on time, but receivership never comes as a surprise then. You've got fair warning with lots of, do you have...
Usually, yeah. I mean, in every court case, in every scenario, the receivership is appointed when there is when there's a court case pending. So there was a violation, there's a building code violation, and then there was a problem. The case was filed, a lawsuit was filed by the city of Chicago, and a receivership, in order for all of that takes place, you'll have to receive notice. So you'll be served with a summons from the city. Usually a Chicago police officer will be serving the summons. Then if the city wants to move to appoint a receiver, they'll have to actually notify and send that to the owner. They have to find the owner and advise him of the fact that a receiver is going to be appointed. Then when you finally comes to that date in court, the owner has a right to step up and say, hey, I don't want a receiver appointed, I'll do the work, but they have to show that they're going to do the work. And there's many of these cases you see that are old as 2009, 2008, 2012, 2011, that have been going on for some time because the city gives opportunity after opportunity to the homeowner to really fix their property on their own. Where it becomes an issue is when they've ignored it, or they're not responding, they're not coming to court. The city has a duty to protect the interests of the public, and that's where they appoint a receiver to come in and do the work.
Yes. Well, again, let's show the audience here how to get a hold of you.
We're at the
Faisal.
Better Informed Housing Corporation, providing education information to communities about real estate. Our number is 312-775-0980, and my email is mfaisal@ev, E as in Edward, V as in Victor, lawgroup.com.
Okay.
You know, the other thing I want to talk about a little bit is about the city of Chicago and how cooperative that they are. I don't want people thinking that the city kind of moves to appoint receivers to take properties. I think we've got a couple more minutes here. But also with building violations, in many cases people are concerned about, you know, the city and the power that the city has. One of the things that I found is that really it's about cooperation, it's about communication. And one of the biggest things that I found as an attorney practicing in this field is in many cases lawyers or people don't actually read the statute and what the violation is. So one major takeaway is if you are being faced with a building violation and the city is saying you've broken a code or violated code, read the code. Find out exactly what it is that they're saying that you broke, because in many cases, well, not many cases, but there are cases where it's an interpretation of the code. So where the city says there was a violation, sometimes there really wasn't a violation. But most of the time it's a very simple fix, and it can be fixed. And even if it's retroactive, I've had a situation where the contractor did work but never got plans or permits, and 3 years later the city was wondering, why haven't you gotten plans and permits? And so those things can be fixed. It seems strange and odd, but it's a matter of going retroactive and getting the plans and permits even after the work has been done, as long as it adheres to the work that was done. So bottom line is, don't be afraid of receivership, understand it, know what the building violations are, read the code, and if you ever have any questions, you feel free to give us a call. And our number, Better Informed Housing Corporation, providing education and information to communities about real estate, 312-775-0980, and my email is mfaisal@evlawgroup.com.
Thank you so much for joining me today.
Margot, thank you for having
Yeah.
me, and I wish you all the best.
Okay.
Take care, everyone.
Okay.